Young Thug trial has been absolutely wild so far, and as the days continue to go on, more and more of the defense attorneys involved in this case are getting fed up with the judge's behavior. And the bad news for the judge just keeps coming and coming and coming. Now, if you've been following along with my videos or the case at all, you may be familiar with the incident that happened last week when the judge, the prosecution, and one of the state's witnesses, YSL Woody, had a closed-door ex parte meeting without inviting any of the other attorneys to sit in and listen. Pretty egregious stuff, but that led to Young Thug's attorney Brian Steele actually filing a motion for mistrial after learning about that meeting. Now, Brian Steele, YSL Steele, the courtroom Superman, actually stood up in front of the whole courtroom and called the judge out for this.
Court handed Mr. Copeland. Tell me how you got the information. Listen, tell me how you got the information, then we can go ahead and go forward. I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court. It concerns me that you have proprietary information. Why is it proprietary? Or information that you should not be having that was ex parte. Why? With a party. Why? State of Georgia. How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court, or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for.
So Brian still argued with the judge for a little minute in the courtroom, filed that motion for mistrial, and the judge immediately declined that motion for a mistrial. He said, no, I'm not approving it. The case is going to continue. I don't care what you're saying. But then he also held Brian Steele in contempt of court and sentenced him to 20 days in jail, which he said was to be served on the weekends for the next 10 weeks, and then he would have to report to the county jail that weekend. Brian Steele asked for bond. The judge denied bond on it. So Brian Steele sent a request up to an appellate court. The Supreme Court ended up taking that. They overturned the judge ruling, said no, Brian Steele is not going to jail. Here's this piece of paper that says he's able to be released on bond, basically overruling what the judge said. But Brian Steele wasn't the only attorney that was upset by the fact that the judge had a closed door meeting with the prosecution and one of their witnesses. So Yak Gotti, who is another defendant in this case, his attorney actually filed his own motion to have the judge recuse himself from the case, to remove himself from the matter altogether, which obviously the judge denied instantly. This led to the defense attorneys basically saying, listen, we need a motion for immediate review by an appellate court, right? Because we're asking you to recuse yourself and take yourself out the case. You're refusing to do that. We want another third party to look into this and see if what we say has merit. But the judge don't have any responsibility to actually make that happen. So he actually denied the request for immediate review as well. Now that brings us up into this week. And this week we've seen Brian Steele actually turn it up a notch. He's went from filing a motion for mistrial to actually filing his own motion for the judge to recuse himself from the case. And he's basically saying, look, man, we're tired of the shenanigans, bro. You got to get yourself out this case. We need a new judge. However, not everybody agrees that what the judge and the prosecution did was wrong, because we actually had the prosecution team stand up and say, look, Young Thug didn't have a right to be at this particular hearing. We had a court reporter in there. We had attorneys in there, and this had nothing to do with coercing the witness. This had everything to do with a contempt of court charge.
We certainly have the right to request ex parte communications. That's why we ask that the court reporter be present. This is a matter that the defendants did not have a right to be a part of, as this was a matter regarding a civil contempt that the court imposed upon a person for not obeying the court's directive.
Now, again, everybody that was in that meeting was the judge, the prosecutors, deputies, the court reporter, a whole gang of people. Everybody except for the defense attorneys was in this meeting. Now, Lil Woody was actually granted immunity in exchange for his testimony on the stand. But when it came time for Woody to get up there and give his statement, he just decided that he was going to plead the fifth and not really play ball with the prosecution.
And Mr. Copeland, good afternoon. Do you want to be here?
Ma'am?
Do you want to be here?
I'm here.
Okay. Are you going to let me ask you some questions?
Okay.
How old are you?
Grown.
Okay, what does grown mean?
I'm an adult.
Okay. And when you say you're an adult, what number in years are you?
plead the fifth.
Okay, so Woody gets up on the stand. He refuses to testify. They go through the whole thing. We went over it last week in a couple of videos, right? I'm not going to deep dive into Woody's testimony for this video right here, but they did eventually get through some testimony with Woody. However, when it comes to that closed door meeting that the judge had with the prosecution and Woody, he was being represented in that meeting by a fill-in attorney, a stand-in attorney, because his main lawyer was on vacation and out of town at the moment. So he was being represented temporarily by this woman named Kayla Bumpus. Well, when Brian Steele called the judge out and said, you know, hey, I know that y'all had a closed door meeting without us, and he filed that motion for mistrial, the judge was mad as hell because he wanted to know how Brian Steele got this information. Well, apparently that information came from Kayla Bumpus. Now, after a little bit of Woody giving testimony, Ms. Bumpus actually filed a motion to have herself taken off the case, as well as Woody basically fired her in the middle of court. However, the judge was so mad that she might be the person that leaked the information to Brian Steele that he decided, you know what? Yeah, you could take yourself off the case, but I need to see you back here in court a week from now so that we can have a hearing so I can find out if I'm holding you in contempt of court as well. So he tried to hold Brian Steele in contempt of court, put him in jail. He's bringing this woman back. He wants to hold her in contempt of court and possibly put her in jail. Like, it's actually pretty crazy in the courtroom right now. Anyway, so he tells her she's got to be back in court so he can find out if he's going to hold her in contempt of court. And that brings us into basically yesterday. We started court with Kayla Bumpus's attorney. So the attorney's attorneys showing up in court and filing a motion for this judge to recuse himself, right? So we've had Yak Gotti's attorney file a motion asking the judge to recuse himself. We got Kayla Bumpus's lawyer filing a motion asking the judge to recuse himself. And on the surface, it seems like what the judge has been doing is pretty unethical. That's how most of the attorneys in the room feel. So that's how we started the day out, was with her attorneys, you know, basically telling the judge that they wanted him to recuse himself. So in this next clip that I'm going to play, we're going to see the judge look at both motions, because there's two that was filed here. There was one by Ms. Bumpus, and then there's another one, a separate one that was filed by Brian Steele. However, we haven't gotten into that yet, but you will hear him talking about two motions. The second motion he's talking about is the one that was filed by Brian Steele. He's going to look at both of them. He's going to read some case law, cite the rules for things that he needs to look for in order to decide if the motions have merit. And then basically he's going to deny both of them.
Another one has been filed under the same indictment, just indictment 22 SC 183572. And I want to say that that motion to recuse has been filed on behalf of Miss Kayla Bumpus. Can I get the lawyers for, or the principal lawyer for that particular case to identify themselves for purpose of the record?
Judge, good morning. Gabe Banks.
Good morning, Mr. Banks.
Her legal team is also here. Mr. Collins, Mr. Novey, Mr. Mormon, and Mr. Winchester.
All right, good morning, counsels. Okay, as it pertains to your motion, Mr. Banks, and on behalf of everyone that is here, I'm going to just take up the issue of the recusal. I'm going to defer the issue of the motion to quash at this point in time, okay? So I'm not going to take up anything. I can't do it anyways because the rules require me to go ahead and deal with the motion to recuse to begin with. And this applies to both motions that have been filed to recuse the court or disqualify the court. Recusal by a Superior Court judge is governed by Uniform Superior Court Rule 25, etc. Rule 25.1 provides that all motions to recuse and disqualify a judge presiding a particular case or proceeding shall be timely filed in writing, and all evidence thereon shall be presented by accompanying affidavits, which shall set fully assert the facts upon which the motion is founded. Filing and presentation to the judge shall not be later than 5 days after the affiant first learned of the alleged grounds for the disqualification, and not later than 10 days prior to a hearing or trial, which is the subject of the recusal or disqualification, unless good cause be shown for the failure to meet such time requirements. And that is cited in Georgia Uniform Superior Court Rule 25.1. So I'm applying that to both sets of motions to recuse. And applying this rule, Georgia courts have held that when a motion to recuse is filed, the trial judge shall immediately, 1, determine the timeliness of the motion, 2, the legal sufficiency of the affidavit, and 3, the legal sufficiency of the grounds, and has no power to do anything else, and that is Robinson versus the state, 332 Georgia Appeals at 242-41. The 3 threshold determinations that the trial judge must make in regard to a motion to recuse are whether it's timely filed, whether the affidavit made in support is legally sufficient, and whether some or all the facts set forth in the affidavit are true, recusal would be warranted, and that is Dacker versus the state, 300 Georgia 74-77, 2016. The judge finds any 3 of the conditions have been met. No, I'm sorry, take that back, strike that. If the judge finds that all 3 conditions have been met, he must refer the motion to another judge to hear the motion, but if any one of the conditions is not met, there is no error in denying the motion. And motions to recuse are viewed and considered by the appellate court for abuse of discretion. Accordingly, the court is going to address each one of the factors as it pertains to both Mr. Steele's motion and, for shortness, Mr. Banks' motion. I find both motions were timely filed. I find that Mr. Steele's motion was in fact filed on this past Monday, which would have been the 17th of June. I find that Mr. Banks' motion on behalf of Ms. Bumpus was timely filed, as it was filed on the filed on the 14th of June at 10:40 p.m. Secondly, I find that in addressing the legal sufficiency of the affidavit, that means, was it sworn? Was it sworn before a notary? Is in proper form? I find Mr. Williams and Ms. Bumpus's motions to be, or I should say affidavits, to be in proper form. The third thing that the court has to review, and like I said, I reviewed, is the legal sufficiency of your grounds of the motion. And here's where the court finds that upon a review of Mr. Steele's motion and affidavit, as well as Mr. Banks' motion and affidavit, that both contain assertions bare assertions and legal conclusions which aren't sufficient for the court to grant your motion at this point in time and refer it to another judge for it to be heard. So I'm going to deny the motion at this point in time. I invite you all to look at Baptiste versus the state.
Now, I do want to go ahead and add a little bit of clarification here. The motion for recusal from Miss Kayla Bumpus actually isn't for the YSL trial. It's actually for the contempt hearing that they're going to have, where the judge is going to decide if he's going to hold her in contempt for leaking the information to Brian Steele, right? So they're not asking him to recuse himself from the Young Thug case, just from that contempt case. However, it still doesn't look good. Being asked over and over and over again by defense attorneys to recuse yourself in multiple cases in the same time period is never a good look. And that's exactly what's happening here. So you hear him say that he's going to deny both motions because he finds that they have legal conclusions that aren't accurate. Okay, so both of them at this point have been denied. And he also said that he was denying any certificate of immediate review, meaning that he's not planning on sending it to no other judge to look over it. Now, while Kayla Bumpus's motion was to recuse him from the contempt case, Brian Steele's motion was to recuse the judge from the YSL trial altogether, right? And so I got a copy copy of the motion that he filed. And in this motion, he basically centers the whole argument for recusal around that closed door meeting that the judge had with the prosecution and Woody. Now, Brian Steele and his co-counsel who filed this motion say that during that closed door meeting, Woody actually made factual admissions of guilt. And they also say that statements were made from the state prosecution team and the judge to Woody about how much time he could serve or how much time he could be held for if they were to hold him in contempt. Essentially, he's arguing that they coerced him into giving the testimony that they wanted. Now, Brian Steele says in this motion that the judge denied his request for the transcript of the ex parte meeting, right? Because remember, there was a court reporter, a recorder in there. And so Brian Steele requested a copy of that transcript. And the judge also denied the timely motion for mistrial based upon this improper and illegal ex parte meeting, which Brian Steele says violated Young Thug's constitutional and statutory rights, including his right to due process, a fair trial, and the right to be present at every critical stage of the proceeding, right? So that's what he put in the motion for recusal. And just a second ago, in that last clip that we watched just a second ago, we heard the judge deny both motions, the one from Ms. Bumpus's lawyers and the one from Brian Steele. This is the other motion that he denied. He said that he did find it was filed in a timely manner, but he still said he wasn't going to recuse himself, and he also wasn't going to grant the mistrial that was also asked for in this motion. So once the judge was done talking to Caleb Bumpus's attorneys, Brian Steele actually stood up and essentially called the judge out again.
I have read Baptiste versus State. I've read all the cases that I believe are applicable. I'm, as best I can. But specifically, if the court would reconsider, and if nothing else, the Honorable Keith Adams and my joint affidavit in paragraph 12, we assert not a bare assertion or a legal conclusion, but we make facts that we specifically adopt from the Honorable Attorney Winchester, Collins, Banks, Nove, and Mormon's motion, where a person that they represent was in a meeting ex parte with the court and others and the prosecutor and a witness, and specifically they wrote in a pleading and under Parish, which is P-A-R-R-I-S-H versus State, which is 362 Georgia Appeal, 392 Division 1, 2022, the lawyer's pleading on behalf of the client becomes a statement of the client. And they said that this court got involved with speaking with Mr. Copeland and assisted in Mr. Copeland testifying against Mr. Williams. So I've added this court to the witness list. I plan on calling the court as a witness in the trial. I added lawyers Hilton and Love from the district attorney's office to the witness list. And when I cross-examine Mr. Copeland, when that day comes, I'm going to ask him about how much pressure, if any, the court put on him. And you're going to be the one instructing the jury. And I just can't imagine how that's fair to Mr. Williams. So I just asked you, I'm not abandoning anything in the joint affidavit from the Honorable Attorney Adams and myself, but if you would just look at just even paragraph 12, again, if you didn't consume it entirely, I don't believe that meets a legal conclusion or a bare assertion. I asked the court to recuse.
I've read your affidavit, Mr. Steele, and I've consumed everything on it, and that doesn't change my ruling at this point in time, respectfully.
Now, one of the main things to note from that clip that we just watched is that Brian Steele said that at some point during the YSL trial, he intends on calling not only the judge up to the stand as a witness, but a few members of the prosecutor's team up to the stand as a witness as well. And he's arguing that the judge made himself a witness to this case by having that closed door ex parte meeting. And I mean, could you guys imagine if Brian Steele does end up calling the judge up to the stand as a witness witness, bro. Like, I ain't gonna lie, that would be monumental, hysterical if that actually was to happen. Like, that would be some incredible stuff to witness the judge who was presiding over this case have to take the witness stand like Woody did and give testimony and get cross-examined by the defense's team. I mean, that would be crazy. So the next thing to know is that he was asking for the transcript from that closed door meeting, right? Like, because they said they had a court reporter in the room, and Brian Steele is saying, cool, I want a copy of that transcript. In fact, he's been asking for over a week to obtain a copy of it.
I also, on the transcript, I'd like the recordings and the transcript, and I object to the court going through it and deleting, because to me, the way I understand it, there is zero privilege. So I don't understand
I'm not gonna, Mr. Steele, I can't argue with you about anything such as I've made my ruling, okay? If you have some other basis to ask for the recordings or anything like that, you're gonna have to put those in some other pleading. But at this point, Miss Weaver's gonna prepare the record. She does that. And like I said earlier, the record should be ready soon. And you all, as a defense group, will have the opportunity to take a look at that particular ex parte transcript that was done in chambers, less anything that is totally that the court considers to be privileged. And I'm going to let you do that before you examine Mr. Copeland. So you'll have everything that you have at that point in time.
Thank you.
All right.
So it sounds like the judge is going to go ahead and release those transcripts from that closed door meeting over to Brian Steele. And man, I honestly cannot wait till they get their hands on them, because as soon as they get them, they're going to leak them to the press. It's going to become public. We're all going to actually get to see what was said in that closed door meeting, which could be very interesting. But right or wrong, the judge is standing on business. He ain't budging. He's not recusing himself. He said, nope, the trial is going to continue no matter what. And I mean, it's a sticky situation for sure. And right now, it's got a lot of people looking at the judge sideways. And that's because ex parte meetings like this are generally frowned upon, right? They're not looked at as a good thing. There are general exceptions to that rule, right? Times that ex parte meetings could be had behind closed doors. But in general, it's frowned upon in the legal system to have these type of meetings unless one of those general exceptions is met. Now, the judge is saying that this was only for contempt for Woody, so there was no reason for the defense team for Thug to be there. He said there was a court reporter, there's transcripts, all this stuff. But at the end of the day, he made a move that anybody in the legal system will tell you is pretty much frowned upon. But that's where we're at. We got defense attorney after defense attorney asking this dude to recuse himself. He says no, he's standing on business. And man, it's been a wild trial so far. I'm gonna keep y'all updated as it continues to go, but that's where we're at with this video. Anyways, if you guys enjoyed the content, be sure to hit the like button, subscribe, tap the notification bell so you get notified every time I upload a video. As always, it's been fun rocking with y'all, man. I'm out.